While a president may have very little direct influence on policymaking, he is given substantial leeway to choose the administrators, advisors, regulators, and cabinet members whose job it is to work with Congress to implement his agenda. These people play a big role in guiding the country to the left or to the right for a term or two. But the long-run impact of a president occurs not through executive agencies, but via the courts, where the president's judicial philosophy is carried out for years or decades after he leaves office. Whereas Bush surrounded himself with loyalists who are more concerned with ideology than pragmatism, Obama has proven the opposite. Many of his cabinet members are heavy hitters and critical thinkers who don't have long-standing ties to him. As the administration gears up to nominate someone to replace retiring Supreme Court Justice David Souter, the speculation is that this person will be somehow different from all other members, either a governor, a Latina, a black woman, an Asian, etc., who is more than a reliable partisan. Above all, Obama stated that he wants his nominee to be, quote, someone who understands that justice isn't about some abstract legal theory or footnote in a casebook. It is about how our laws affect the daily realities of people's lives. He hopes that his pick will see that the, quote, quality of empathy, of understanding and identifying with people's hopes and struggles is an essential ingredient for arriving at just decisions and outcomes. Already, though, that harmless word, empathy, is throwing some conservatives into a frenzy. According to them, having empathy is code for being an activist judge, or for being pro-choice, or for siding with the consumer over big business. Judges don't have empathy. Empathy clouds judgment. A judge's business is to read what's in the Constitution, apply it to the case, and decide who is right, not who deserves favorable treatment. The problem with this argument is that the Constitution is not so clear, and was never intended to be clear, on a range of issues that did not exist in 1789. And to that end, being book-smart regarding the thousands of relevant statutes and precedents may not be enough to answer the challenging questions of tomorrow. Throughout the country's history, judges have been senators, representatives, soldiers, bureaucrats, and even a president. William O. Douglas was an outdoorsman who famously helped save the C&O Trail for hikers and bikers while he sat on the bench. The point is that being a judge does not necessarily require a two-dimensional personality of encyclopedic case law knowledge. A judge who is familiar with the political fault lines and the roots of social disorder may bring a unique perspective. Back in the early days, justices were appointed from different regions of the country in the name of diversity, since communication and differential economic growth had not yet homogenized the nation. A judge must be able to realize that both parties in a case can be right in principle, but that good law must level the playing field for the greatest number of people. And that is how schools become integrated, poor defendants gain access to lawyers, and children are protected from hearing profanity on the radio. Of course, all decisions involve trade-offs, between freer commerce and protective regulation, between liberty and safety, between social custom and ultimate equality. And the fear that Obama's judge will be an activist is a mistake conservatives often make in referring to a liberal judge. The right wing of the Supreme Court overturned Washington, D.C.'s gun control laws last summer in a moment of activism. It's unfortunate that the idea somehow bothers conservatives that rendering social justice means making a mockery of real justice. Hopefully, Obama's nominee will be able to prove able to blend the Constitution, law, culture, and history into an understanding of what her or his ruling will mean for individuals, groups, and principles. For the 28th Amendment, I'm Michael Carlick.